So, but I did anticipate this, going last, you're going to be like, it's like the end of the bar exam, trying to get through it. So we're going to keep it kind of light, and we'll start with the video.
Live from the CBS Broadcast Center in Los Angeles, this is CBS 2 News at 6 p.m.
Thanks for joining us. I'm Jeff Ball.
Hello, everyone. I'm Susie Sub. Pat Harvey and Paul Majors are off today. A Playboy Playmate Snapchat photo may land her in both criminal and civil courts. Danny Mathers admitted to posting a naked picture of an older woman in a gym locker room.
But as CBS 2's Randy Page reports tonight, the model may have to face the music now that the victim has reportedly been found.
Playboy model Danny Mathers has been publicly criticized for posting this photograph on Snapchat, which shows a naked woman in her 70s inside a woman's locker room. Mathers wrote this caption in the post: "If I can't unsee this, then you can't either." Mathers has apologized for the so-called public shaming, but she could find herself in trouble with the law. The LAPD is confirming an investigation is underway. And TMZ is reporting police have tracked down the woman in the photo and that she wants Mathers prosecuted to the fullest extent of the law.
If it can be proven that the person is identified and had a reasonable expectation of privacy, then certainly there is a criminal case here.
Criminal defense attorney Lou Shapiro says the law she may have violated is a misdemeanor, which carries a maximum sentence of 6 months in the county jail.
Generally, on a first-time misdemeanor, someone does not go into custody, but because of the behavior in this situation, it's aggravating and a judge might see custody time.
Shapiro says the former Playmate of the Year could also be slapped with a lawsuit if the woman in the photo decides to make a civil case out of it.
She definitely has a case. And given the embarrassment factor and all the people that are aware of it, I think this is a case that would settle very quickly.
Mathers attorney Tom Mesereau offered a brief written statement which says Danny Mathers never tried to hurt anyone at any time and certainly never tried to break the law.
But as we all know, ignorance of the law is not a defense.
And while she's already been called to answer in the court of public opinion, Shapiro says the inside of a real courtroom could be next. In Century City, Randy Page, CBS 2 News.
Right, so that basically sums up, as they say, where the law, right, is always catching up to the science. Because this was a situation where it was really one of the first times that we've seen it, in the high-profile context, where you have this invasion of privacy statute here taking place. So what are the elements, right, of invasion of privacy? Pretty simple, right, intuitive. One is the person used a camera. Two, that it was secretly done. Three, it's without the consent. And then we have it could be a bedroom, a bathroom. And finally, four is with the intent to invade the privacy of the other person. So it's really hard to defend a case like Danny Mathers where these are your elements. The only element you can try to argue is element number four, that when I posted it, my intent was not to invade the privacy, my intent was to make a statement. But you could imagine how that would fly with the jury of our peers. So therefore, she did what was anticipated. The first court date, which is actually very rare, but she took a deal right off the bat. She pled to the misdemeanor charge. She was given 30 days of graffiti removal, and she's put on summary probation. Early acceptance of responsibility obviously played in her favor, and there really was no way out. There was no legal defense that she could have presented to challenge this, so she did what she had to do in taking early responsibility. We don't see so much of that, though, because most people are not going to go to the extent, right, of taking a picture of someone in a locker room and posting it on Facebook or Instagram. But this one, we actually do see. This could be, your friend, your neighbor, or a loved ones could apply. This form of electronic harassment now, also referred to as cyber stalking, Penal Code 646.9. We have to cite Penal Code so we sound smart up here, right? So it is what it sounds like. It's basically the annoyance, harassment. Here are elements. It's repeated. Usually one time is not going to do it. So the district attorney's office is looking for repeated conduct. Number 2, it's got to be threatening. 3 is it has to be specific intent. Anyone remember from law school what is a defense to a specific intent crime? Want to jump in at this point? It has to do with alcohol or? Thank you. Voluntary or involuntary though?
Both.
Right, very good. Usually someone would only say involuntary intoxication, but actually voluntary intoxication is a defense to a specific intent crime. So you can anticipate, now you know what defense to use. If you're ever charged with electronic harassment, I was drunk, and negates the specific intent. I hope I was not recording at that moment. Finally, number 4, the person made the threat with the apparent ability to carry out the threat so as to cause the victim fear. So it's got to be like, oh my God, I really think this is happening, and that was the intent of the person to convey that. But it's actually what a reasonable person would convey as a threat. So if you could say, I was just really horsing around, but if this person was really felt really threatened and it happened repeatedly, you don't want to go to court on that one. And then finally we have the third code that's kind of hot, and that's revenge porn. This is the case where someone is intentionally posting a picture which you would not want going on the net. The only difference is between that and the invasion of privacy one is invasion of privacy you did not have. It's kind of like embezzlement versus theft. You did initially agree to take this, but as I like to say, from theft to embezzlement, you take a lawful possession and you convert it to unlawful. So that's kind of the analogy here. With revenge porn, you're consenting to the initial taping of the rendezvous. I like using that word rendezvous. It's very sanitary, right? But then someone takes out the taped rendezvous and puts it out there without your consent. Number 5, again, that may be the only element one could try to challenge. The person depicted suffers serious emotional distress. Good luck to trying to convince a jury that the person did not suffer emotional distress from this. I want everyone to bear in mind that the civil restraining order overlaps a lot with these cases, right? So you have someone making maybe a criminal report to the cops, but sometimes cases don't always materialize into criminal charges, and this person is still harassing you, right? They're still bothering you, bothering your girlfriend or an ex, crazy ex. So you can take matters into your own hands, and you can file a civil restraining order. They are free to file. So you can get the petitions online. Don't waste your money on a high-priced lawyer for this. Unless you hire me, that's okay. That's the exception to that. But you basically go to court, you file it, and then you have to prove to a judge at a permanent restraining order hearing that there is clear and convincing evidence of harassment, annoying, stalking, etc. The functional way it works, if you don't know, is when you file the petition, you get a temporary restraining order that's almost always issued by the judge, so you walk out there celebrating, but that's only temporary. You have to serve the respondent, another fancy lawyer word, with the petition. They have to get notice of the hearing. They come to the hearing and duke it out there. There are defenses, and there are creative ways around these if you are the respondent, right? Because, just last week, I was representing a 21-year-old college boy, and he was going through this drug episode. He had a brain neurological disease, very sad case. Met a girl in a church. She wasn't into him, and of course, he thought maybe the best way to get her attention is to stalk her and create fake profiles on Instagram and so forth. So petitioners, like his lawyer, her lawyer comes to court with a book of exhibits and everything. I'm like, how are we going to do this? But there is always a way. So. You do try to use sympathy when you can. We had medical records, and we showed the judge how, this boy really did suffer a neurological disease in high school. It's a very sad situation. He's currently in therapy. He's seeing a psychiatrist. He's under the care of medication. And most importantly, what judges look for, if you're on the defense on this, is that there hasn't been any breach of the temporary restraining order. Because there's usually a few weeks between when you get the temporary restraining order and the permanent one and the permanent hearing. So you can say, Your Honor, look, it's been 3 weeks. This guy is shown everyone that he, can behave himself, and the actual danger, the imminency is no longer there. So in that case, what the judge did was he said, I got an idea. Rather than having this college kid have a permanent restraining order on his record, he's going to apply to grad school. It's a red flag. The judge says, I will extend the temporary restraining order for 3 years, as long as he doesn't violate the temporary restraining order for 3 years, at the end of 3 years, I will dismiss the temporary, so he will never have a permanent restraining order on his record. Another thing one can do is you can enter into these like private agreements with the other parties. Say, I promise never to do it again. Let's sign something. I'll draft it up. And it's not like these things are dismissed with prejudice, so you can always refile it if there's ever a breach of that private agreement. Examples that are not revenge porn, if it's in the course of reporting unlawful activity, which is similar to recording someone when they're threatening you. You can record, we can't record people when they're saying something to us without their permission unless they are threatening us or committing a crime. It says it's not revenge porn if it's in the course of a lawful public proceeding. I've yet to see that example, but remains to be seen. No video for that one today, sorry. You may be asking yourself, right? These were some, high-profile cases this year, right? We had the Kardashian one where he's posting pics of Blac Chyna, spelled C-H-Y-N-A, not C-H-I-N-A. And Misha Barton to the right. As anyone for extra credit know who Misha Barton's attorney was? No one. Lisa Bloom. Come on, where is? Does anyone know, for additional bonus question, who is Lisa Bloom's mother? Thank you, Gloria Allred. Very good. Okay, so you got to wonder, right? With all this media attention, right? Press conferences. Why didn't the DA's office file criminal charges? It seems like a slam dunk on these cases. The reason is as follows. Number one, a police report needs to be made. So we could be watching this all day long on television, but if the alleged victim does not file a police report, there's nothing for look number two, for the district attorney to even consider filing a case on. You can't file a case on thin air, even though they know it happened. The district attorney, this is how any criminal law process goes, they decide whether or not they're going to file charges. So just because a police report is filed doesn't necessarily mean that the DA is going to file a case on it. Every day, County of LA, right, there's thousands of calls, arresting officers respond, they prepare their police reports, and they bring stacks of police reports to all these DA offices in every courthouse in the County of LA. They've got 30 of them. And there is a filing prosecutor in each courthouse. And what that filing prosecutor's job is to do is go through stacks of police reports and decide which ones will live and which ones will die, basically. And that's why I have attorney intervention between 2 and 3 is crucial. Law and Order and these shows, these criminal law shows, it always shows the trial and the defendant being found not guilty or the opposite. But I think that what doesn't get reported and the real victories is when a lawyer can avoid the filing of charges altogether on the client, save them the court time, save them the headache, present to the filing prosecutor the other side of the story. So that way when the prosecutor is deciding, whether I'm going to file this case, like, hey, wait a second, I didn't know, there's a pending divorce proceeding in this domestic violence case, and if there's criminal charges, there's going to be a spousal support, child support issue here. You have all these kind of moving pieces, get that out there. So again, if there's no report at the end, then there's no crime. And if there's no victim, there's no crime. And that's why these cases did not go the criminal route. Finally, feel free to keep in touch with me. There's my contact info on there. I use Facebook to disseminate and exchange controversial legal viewpoints. Please don't agree with me. That's just boring. So by all means, join up. And I just want to say I am a little disappointed. There was one guest who's not sitting here today, and that is the monkey that won that lawsuit, right? That's going to be getting royalties, right? And so I was thought right here, I get a selfie with him.
We should have talked about the monkey, you're right.
Right, so part 2.
Settled. I thought, I did think about bringing the monkey selfie case up, but the real issue there was standing and whether, the monkey's right to sue or whatnot, so we kind of excluded it, but it is a really fascinating topic.
But considering the standing issue, he settled. The monkey won. Yeah.
Because they let the guy dry.
Yes.
The poor photographer couldn't afford his legal fees. So thank you very much. We can open it up to questions if anybody has